Welcome to the Mulcahy Law Firm podcast. For over 25 years, Mulcahy Law Firm has helped plan communities and condominium associations throughout the state of Arizona.
The intent of our Zoom, Facebook Live, First Friday free call-in, videos, and podcast is to provide a forum for board members and community managers to receive answers to HOA and condo legal questions. Please note, the content of these sessions are general in nature and is not intended to and should not be relied upon or construed as legal opinion or legal advice regarding any specific issue or factual circumstance. You should directly consult with an attorney for advice regarding your individual situation.
Welcome to the podcast.
Welcome to our June First Fridays virtual free call-in. My name is Beth Mulcahy, and I'm the founder and senior partner of the Mulcahy Law Firm in Phoenix, Arizona. How can it be June? I cannot believe that the year is almost half over. My kids get out of school from school next week, and I know the temperatures are starting to rise in Arizona. So hopefully some of you are already away for the summer in the Midwest or the Pacific Northwest, enjoying some cool weather. But for those of us who are still in the heat in Arizona, we have a lot of great questions and answers here today for you, so we're going to get started on them shortly. Just as a letter of introduction, my name is Beth Mulcahy, and I've represented HOAs and condominiums as their legal counsel and attorney in the state of Arizona for over 27 years. My firm currently represents over 1,000 planned communities and condominium associations throughout the state of Arizona. Welcome to our firm's live virtual First Friday event for June 2024. First Fridays, as you may know, are a great time to get your questions answered on Arizona HOA and condominium law at no charge. Here's how First Fridays will work today. If you haven't already done so, please submit your First Friday questions in the Q&A box on Zoom or in the comments section on Facebook Live as soon as possible. And then I will answer all questions between now and about 10 or 10:15, 10:30 this morning. Just a quick and friendly reminder, because we get so many questions for First Fridays, today we have already over 55 questions. This is a free opportunity, is limited to just one question per association. So if you plan on submitting a question live during this session today, please include the name of your HOA and condo and your current role when you submit your question. Thank you so much for understanding. We're going to get right into the questions in just 1 minute. As you probably know, the legislature in Arizona started their legislative session on Monday, January 8th, 2024. We continue to track the bills that have been introduced this year and passed into law by the Arizona legislature and signed by our governor. None of the bills are going to go into effect until 90 days after the legislative session ends. Since the legislative session is still open for this year, we're not going to spend any time today because there may be some new bills that are going to be added. However, we have a great summary for you, a brief summary of what the bills are this year that have passed. And again, none of these bills will go into effect until 90 days after the legislative session ends. So just kind of a primer, put your toe in the water so you hear what's going on. Once the legislature closes in Arizona for this year, we will have a class dedicated to talking about the changes, and we'll be talking about them probably in every class for the rest of 2024 once that happens. Okay, let's get right into our questions. I'm going to do a question count here real fast, see where we're at. Okay, we are at 56 questions, which is awesome. So let's dig right into them. Our first question is from a member of an association. My HOA sent out to all members on our HOA thread the minutes of our last meeting. In the minutes, it made reference that two members are cyberbullying them, referring to me and stating because of me, they need a management company. I did respond as the story is fabricated. I then received emails from other members asking me to never email them again on the HOA feed. How can we handle our HOA platform so people like me are not personally attacked? Okay, whenever I see a situation like this, I have to look at it kind of from like a 360-degree view, right? Because obviously the board feels like they are being attacked and you feel like you are being attacked, right? And so the truth is probably somewhere in the middle, right? And so here's my best advice to you. I think that you have to get along. When we live in associations, we have to find common ground and try to get along. So what I would recommend is that you attend a board meeting in the future and you try to resolve any differences that there may be with the board. In terms of the HOA feed, I'm not exactly sure what you mean by that. Maybe it's like a Facebook page, or maybe you have a special, feed for your association. I think there should be some ground rules on the feed, whatever that may be. And obviously that would mean no personal attacks. There really should be positive dialogue on the feed. Obviously there can at times be constructive criticism or constructive suggestions. But we don't want anybody feeling like they're being bullied on either end. So I think you need to have good communication. One thing that your association may want to consider doing is having our firm come in and do a boot camp so that we can talk through some of these issues, because hiring a management company can be very expensive for your association. It doesn't look like you've had one in the past. Maybe some of these issues can be resolved by having me come in and mediate some of the disputes and moving forward proactively. Okay, next question, number 2, is from a board member. Recently, I reviewed 3 years of our community's 2 water meter bills, and it's apparent our irrigation is not being properly managed. Some months, one bill spikes to 3 to 5 times the other bill, which does not correspond to normal summer heat increase of water schedules. This amounts to $3,000 to $5,000 annually over the last 3 years, probably going back longer. Communication back from the landscaper on addressing the way and how to address the issue is, shall we say, challenging. Okay, a couple thoughts. So there are different times each year, based upon my experience, where the water bills are higher. And those typically are during the hotter months in Arizona, and also when you're doing the overseeding in October or November. So I don't know specifically what's going on here. Sometimes a spike in the water bill can be due to a leak, an undetected leak, and that can be very expensive. I mean, I guess from my perspective, if you're trying to communicate with the landscaper and the landscaper is pushing back or, not giving you the answers that you think that the board needs to make good decisions and act in the best interest of the association, you may want to look at the contract of the manager and think about making a change. There are some experts out there that can come out and look at your irrigation system and give you some suggestions on how to best manage the situation so that you don't see, any leaks that may be causing a spike in the rates. Okay, next question is from a past president. Our property manager has not been able to provide any alternate landscaping companies that are close to competitive or replacement consideration. What should we do? One thing that you might want to do is reach out to our firm. We can give you a list of, management companies, landscaping companies to help you. You also can check with the Arizona Association of Community Managers. I think they have a vendors list on their website. The other thing you want to do is ask neighboring associations, who they use if their landscaping looks good. And if you need to find out the contact information for neighboring associations, reach out to me. I can look that up on the Corporation Commission and help you find who the contact person is. So there are plenty of alternate landscaping companies out there. You just need to get the resources and contact the right people to give you some different names you guys can interview. Okay, next question from another former board member. I was hassled with threats of monthly violations if I don't let them paint my new security door. Our CC&Rs do not assign security doors to the association, and I told the board this. Also, the board member came with 2 workmen by herself and had no previous request, which if I had been, I would have said no. What can I do? I have written an email to the management company and the president and have received nothing in response. I asked that the door be replaced with a new quality door like the one they painted. Okay, so it sounds like you have a security door on your property. It sounds like the board painted that security door, maybe as part of a widespread painting project. I don't know. I really think without seeing the CC&Rs, it's hard for me to comment on this. So I would encourage you to find an attorney to help you navigate this situation. I mean, I guess from my perspective, I think maybe that the association probably did have the right to paint this if they were doing it as part of a repainting project, and the association is responsible for the exterior of the property. but I don't know all the facts. Maybe there's a specific exemption in your CCNRs that says, doors are the responsibility of the owners and not the association. So I think you need to get separate legal counsel to help you with this. If you need the names of some referrals, attorneys that represent owners only, reach out to me by email and I can provide that to you. I'd be Mulcahy at mulcahylawfirm.com. Okay, next question, number 5. Our HOA is facing a major insurance problem. Our insurance tripled, and we are having a hard time finding a way to get it back down due to a claim 2.5 years ago. We also have aluminum wiring. No one wants to touch us. Our insurance carrier knows we are trapped. We've gotten the insurance down from $37,000 down to around $31,000 or $30,000 when it used to be $12,000. Our president states that we cannot mandate that people carry their own insurance on their units. I should let you know that I'm aware in order to do this, we would have to change our CCNRs because it's state law that HOAs have a master policy. But this may break some of our homeowners as they are unlimited income if we keep our insurance as it is and then place the roof coverage at cash value rather than what's worth to roof, which would probably add more to their homeowners insurance if they just had homeowners 6 right now. And if they were able to keep our policy and pay triple, this could add almost $100 a month to the homeowners. This is a long question. Okay, my question is whether or not the association can mandate owners to carry their own insurance. This is kind of a tough question. It sounds to me like maybe you're a condominium. So there are some specific requirements in the Condominium Act regarding insurance. So a couple of thoughts. Everybody is seeing, every association in Arizona, in California, Nevada, New Mexico, the West has been hit hard by, insurance companies raising their rates. So you're not alone. And I'm not necessarily sure it's due to a claim that was made 2.5 years ago because I have many associations, mine included, where we haven't had any claims in the past 5 years and our insurance tripled too. So a couple of thoughts. I think the easiest way to handle this would be, as you're doing your budget, you need to adjust your budget numbers for the insurance. And I think the association should continue carrying the insurance because, at least for now, because you don't have time immediately to amend your CCNRs to possibly change the coverage to the homeowners. I think you're going to have to be really strategic on your claims for your insurance. You should not be making claims that, are less than the deductible, right? If the claim is really something that should be covered by the owner because the owner, may have caused the damage or something like that, careful analysis needs to be done on each claim. Yes, you could look into amending your CCNRs to change the insurance coverage to have the homeowners carry it themselves. I don't know how your association is structured, if you're a planned community or a condominium, and I haven't seen your CCNRs. So in order for me to give you a better analysis on that, I would need to see all of those different documents. Okay, question 6. Are there any constraints on ballot harvesting on election, and what are those constraints? I'm not really sure what you mean by ballot harvesting. I guess maybe it means like actively seeking ballots for elections. So I guess maybe my office can look up what that is, but I'm assuming I should know this. It's an election year, right? I should be thinking I know what this is, but I'm not sure I'm answering your question fully. But okay, so I think if you're meaning that ballot harvesting is that, people are taking ballots and, okay, here we go, my office. I have the best office. Morgan, you are the best. Thank you. Okay, ballot harvesting is defined as collecting completed absentee ballots from voters and delivering them to polling places or election offices. These efforts focus on helping voters to get their ballots in on time. Okay, so here's what I would recommend. Are there any constraints? I don't know how your association has set up their elections or the voting on whatever issue that you're voting on. But the way to fix this is to make it very clear how ballots can be returned in an election. So this is obviously for like HOAs and condominiums. I'm not touching the national election or any state elections right now. But So the way to kind of, if you're worried, I think what happens typically is sometimes people get worried, well, somebody's going door to door and they're, racking up 60 ballots and then they're going to bring them to the annual meeting and hand them in on behalf of those 59 owners that they collected the ballots from. The way to avoid that is when you send out the election ballot to make it very clear that these are the only ways that the ballots can be returned. So that the owner can return it by mail using this envelope or whatever, or the ballot can be returned by email, with a copy of the, ballot, a picture, is returned back to the association. Or the owners can vote in person. We have to let owners vote in person under the law if they want to. The other alternative is by absentee ballot. But really the best way to avoid this would be just to use an online voting company. There's a number of online voting companies that handle elections like this, and there's no way it's bulletproof. There's no way that another person can log in and vote in an election if you do it that way. So, I think you can control the ballot harvesting by having very specific instructions, and maybe say something like, we don't allow an owner to show up with anybody's ballot other than their own, type of thing. There are ways around this, of course. But those are some suggestions to help you if you feel like there may be ballot harvesting. And those type of constraints can be set up through using an online voting system. HOA Vote Now is kind of the popular one that's being used right now by a lot of associations, or by very specific instructions on the ballot on how the ballot can be returned. Okay, question number 7 from a board member. When preparing minutes, are we supposed to notate who was the first and second for a motion, or is it preferred to not mention names? We have gotten mixed answers from various sources as to what is required. Okay, we have a great cheat sheet on this topic called Community Association Board Meetings, which we're going to be sharing with you now on Zoom and on Facebook Live. I guess my feeling is there's no hard and fast rule on this, okay? I would say most associations do not include who was the person that made the motion and then the second to it. But some do. And it doesn't really matter, frankly. If it's a very hotly contested issue, maybe you want to have that information there. But what matters is, the vote, right? So if you have an issue that is going to be contested or it's very controversial in your association, I would have the person who makes the motion's name listed, the second listed, and then how each vote was cast by each individual board member. But again, there's no hard and fast rules on this. That's just a suggestion. Okay, question number 8. During HOA meetings, when they happen, we never hear which board members vote for agenda items. Should I request this or should I record the meeting? The meetings don't reflect what really occurs. Okay, so second question on board meeting minutes. Again, take a look at that cheat sheet that I just shared on this backside of the cheat sheet on community association board meetings. It talks about how to take perfectly proper minutes. Okay, so you don't hear which board members vote for agenda items. I'm not sure what you mean by that, because during an HOA meeting, there should be a call for a vote, and you should be able to hear how people are voting. Now, maybe you're listening in on Zoom or something like that. I don't know. Or maybe everybody's on Zoom and you're not sure how everybody's voting. One thing that you could do, they're not required to do this, but one thing that you could do is just say, hey, I'm interested in hearing how each person is voting. Can you do like a roll call vote where each board member votes on certain issues? Now, they don't have to do that, but that's something that would maybe help you determine how someone voted, or ask them to put it in the minutes is another thing. But again, the board makes a decision on this. If you're not on the board ultimately decides whether or not to do it. And there's no hard and fast rules saying they have to do it that way. Okay, next question, number 9. I read in the last Community Associations Institute Journal that the Corporate Transparency Act was still viable regardless of a lower court ruling finding it unconstitutional. CAI recommended being prepared to abide by the law and the deadline for January 1st, 2025. What is the status of the CTA, and should we be readying our associations to be prepared to meet the 2025 deadline. And this is just a director from an association in Arizona is asking this question. So we have a great blog article that we wrote on the Corporate Transparency Act that we're sharing with you now on Zoom and on Facebook Live. So I encourage you to take a look at this. I think this is really a big question mark in our industry. Right now, as it stands, yes, associations in Arizona do need to fill out the paperwork to comply with the Corporate Transparency Act by January 1st, 2025. The paperwork is not difficult. It is, a couple of questions and some information from board members on how to be contacted, et cetera. And it's going to be a hassle because we're going to have to update it every time there's a change in the board. There are some national companies that are helping associations with doing this for a charge. Also, there are management companies, I'm sure, in the Valley who are probably helping their clients with this for a charge. I guess my feeling is, yes, right now you still do have to comply with it. Do I think this law was ever intended to apply to HOAs and condos? No. Do I think this is a good thing for associations? No. Do I think at some point the legislature is going to wake up and correct this in the United States Congress? Yes. I know that CAI has been filing amicus briefs and a couple of national cases to make it clear that this doesn't apply to HOAs and condos. I don't know what's going to happen on this in the next 6 months. So my best advice is it's an easy form. Don't stress out about it. You can get this done in December of 2024. And I think I would just kind of hold tight on it until December 1st and then make a decision. If it's the same as it is right now, we have to comply with it. And you can guarantee I'm going to be talking about this all the time, starting in November and December and, giving my opinion on what associations should be doing. So right now I would say hold tight. And, by December 1st, you're going to have to make a decision. And again, it's an easy form. It's an easy form that you can fill out in less than 10 minutes. So don't stress about it, but stay tuned. Okay, next question, number 10. Regarding the new Phoenix and Arizona regulations regarding ADUs and casitas, can we, a 60-home gated community with private streets, elect to remain under the old Phoenix regulations? i.e. can't build on more than 45% of the lot and no kitchen or stove allowed. I'm going to ask my office. Maybe we can have Madeline take a look at this while we're on the First Fridays today and just kind of give me a quick little update. We'll add this to the end and then I'll add this one at the end. I am familiar that they are allowing ADUs, which is alternate dwellings, on properties and casitas, but I'm not quite sure 100% if this is going to apply to a planned community that's gated. So I'm going to have my office take a quick peek at that, and then we'll add this question to the end. Okay, number 11, from a board member, a homeowner in the community has unapproved architectural change that impacts the structural integrity of the bordering common property and will likely be several $1,000s to remediate. There is open violation regarding the item on the property. If the house is sold, does this open violation automatically convey so that the owner is liable for financial remediation at closing? So it would be like a lien, but less fuss. Okay, we have a great cheat sheet on enforcement of association governing documents that my office is going to be sharing with you shortly. They have not already. So I would recommend that you take a look at that. The bottom line here is, okay, you have an unapproved architectural change. It's an issue. It's a safety issue, apparently, because it is affecting the structural integrity of a bordering common property. And it's going to be a couple $1,000s to remediate. So under the law, if your association has 50 or more units or lots, the association is going to disclose at the sale of the property. So when the property enters escrow, if their records reflect any, violations on the property, that's your time to let the buyer know that this is an issue. And if this former owner, the current owner, seller of the property doesn't rectify it, yes, the buyer is going to be responsible for rectifying it or paying the fee to rectify it. So definitely the time to make this issue discussed is at the close of escrow, and the way to do it is on the disclosure statement. I don't know how long it's been there. The owner may have some arguments, legal arguments as defenses, but mean, the bottom line is it is something that is damaging the common areas, and they can't do that. And it needs to be rectified at the time of the closing of the sale of the property. Or the buyer accepts it, and they're going to be on the hook for it. Okay, question number 12 from a board member. For annual election of board members for our HOA, our governing documents allow cumulative voting to elect board members. We have a 5-person board where officers serve 2-year staggered terms. Our elections are for 2 board members every 2 years and 3 board members every 2 years staggered. We have used cumulative voting in previous years. Now, one of our board members wants to eliminate cumulative voting for board members, but has not offered an alternate voting process. The board member wants to have this matter as an agenda item for our next regular board meeting in July. We meet quarterly. What are your thoughts about using cumulative voting for electing board members for HOAs such as ours? Well, my thoughts on cumulative voting is, and just a quick explanation, cumulative voting is like, let's give your example. We have 3 board members up for election this year. Let's say, just give an example. And so each owner will get 1 ballot, right, to vote. And on that 1 ballot, they will have the opportunity to vote for 3 candidates because there's 3 spots that are open. If you have cumulative voting, and let's say that there's 3 spots open on the board and 5 people are running, cumulative voting means that when they vote their ballot, they could take all 3 votes and vote it for 1 candidate, or they could go 1-1-1 for 3 different candidates, or they could go 2 votes for a candidate and 1 vote for another candidate. So it just allows you to accumulate your votes. Now, the only way that you can do this is if it is in your documents. Typically, you'll see it in the bylaws of your association. And so, that's how it comes into play. Now, I don't know if your association's bylaws have cumulative voting or not. But what I can say is that it sounds like you do. So if you want to remove that, you really do need to amend your documents to get rid of it. If you have it, I have some associations, it just depends on what the language is. If it says cumulative voting shall be allowed, then you have to allow it. If it says cumulative voting may be used, then any owner who elects to use it can use it, right? And we have to allow that. So if you want to get rid of it entirely, the bottom line is you need to amend your documents. Okay, next question, number 13. 2 new board members, and we shortened up this question a little bit because it was a pretty long question. So 2 new board members ran for the board because the unilateral behavior led to costly mistakes. The new board members haven't received the training they requested. Any questions are met with the hostile answers. The board president creates agendas for the meetings. The new members were told they need to present agenda items at the meetings so the board can vote. If approved, they go to next month's meeting agenda. The 2 new board members have noticed some expenditures that were not emergencies and were not voted on at a meeting. How do you get the president to recognize that he or she is part of a 5-person team and needs to include the rest of the board rather than continuing to make unilateral decisions? So great question. So we see this often when we have new board members coming into the association board and, there's a change of guard, right? And you want more information, you want a seat at the table, you want to be able to put things on the agenda. It's always a difficult situation, especially if you have the former board where maybe things have been running a certain way forever and the president's had a lot of control and maybe that person's not wanting to give up that control. It's a perfect storm for a problem, no question in my mind. What you may want to consider doing is having your association have our firm come out and do a boot camp. And we talk about the fact that, hey, this is a team. We're a team working on the board together. And yes, the president has significant responsibilities. And yes, the president does, typically make the agenda, but making the board members, the new board members, wait a whole month to get agenda items on the agenda, it seems a little bit, ridiculous to me. And we all need to be working together, right? Not trying to shut the new board members out of the process. And I think when we have one of these boot camps, it's really helpful because it gets everybody in the same room or everybody on Zoom. And we just talk through the issues and we talk about what Arizona law requires. What are the legal requirements of being a director? And why do we have these problems? And, we talked through the issue about maybe some of those expenditures that were not voted on properly at a meeting and how we can avoid that going forward because we don't want any liability, and how we can support the president, and how the president can maybe open up the door a little to let these other board members help out. So that's my best suggestion to you as you navigate this new time on your board. Okay, number 14, from a former board member. Our present insurance carrier will not renew the master policy for the association. The board states the laws have changed, which is making it impossible to find a carrier because of the age of the buildings and building codes. The board is trying to change the CC&Rs via a vote to make the condo owner responsible for insuring their entire unit instead of the board maintaining a master policy. What would be a plan B if the vote to change the CC&Rs fails? The board will continue with the liability coverage. The owner would be responsible for insuring against all damages to the unit via fire, storm, etc. Okay, the alternate plan B. So it sounds like your board's trying to change the CC&Rs so that they move the insurance coverage to the individual owners. I'm not even sure that can be done in a condo. I don't know for sure if you're a true condominium, and we have to put the Condominium Act on this. But okay, so if that vote fails, trying to move it to the owners to have insurance, a plan B would be to go into the high risk insurance market and find an insurance company that would give your association a insurance policy. It's going to be expensive because when you go in the high risk market, it gets expensive. But, not having insurance isn't an option. You have a fiduciary duty to the community to protect the assets, of the community. And so that's not going to be an option. So reach out to our firm. It sounds like you guys are in a really difficult situation. I think we've been with other associations, help them in these type of situations, help them navigate the high risk insurance market. And maybe you don't even have to go into the high risk. Maybe you just need to get, an insurance broker to help you try to find a low risk insurance policy. Okay, question 15. Is it a conflict of interest if a board member is also a broker and rents out units? I would say no, not necessarily. As long as they're not using their position as a board member, to influence or, self-deal or anything like that, I don't see an issue with it. What about if a board member also runs a remodeling business while serving on the board? I don't see a conflict there. The only thing I can see is, I need more facts. Like we wouldn't want owners to be told, I can get this approved by the board, even though it's against the CC&Rs because I'm on the board, right? So we couldn't have anything like that. But based on the facts you've given me, I don't think that either of these situations are problematic. But if there's problematic behavior associated with their side jobs, meaning they're using influence of being on the board in their side jobs or claiming they can get things done, that would be inappropriate and a breach of their fiduciary duty to the corporation. Okay, question number 16. The open meeting law exception statute was recently updated. Can you confirm that the agenda and the minutes for regularly scheduled workshops also need to be distributed to homeowners 48 hours in advance, as well as the regular monthly meetings, and that homeowners can speak at the workshops? Okay, so if we look at House Bill 2662, which amends 33-1807 and 33-1248, again, this is one of those new laws that was just passed by our legislature and signed into law by the governor. It hasn't gone into effect yet. It won't go into effect until 90 days after the legislative session ends. But basically what it says is that, we've always had to give out the agenda, just so you know, at the board meeting. Okay, that's been the law for many years. Now, we are required to have the agenda at least 48 hours in advance of the meeting. And it needs to be, similar to the way that you put out the notice of the meeting. And so we've been telling all of our clients since the law changed, maybe 8 or 9 years ago, saying that the agenda needed to be provided to the owners who attended the meeting. We've been suggesting giving the agenda as part of the notice of the meeting for a long time already. But now, once this legislative session ends and 90 days passes, it's going to become the law. So can I confirm that the agenda needs to be distributed to homeowners? Yes, I can, but it's not the law yet. It won't be until the legislative session ends, and then add 90 days to that. It needs to be done for workshops and regular board meetings. A workshop is considered a board meeting because you have a quorum of the board there present discussing association business, even if there's no voting. Okay. Question number 17 from an owner. If the HOA board had a problem with the contracted management company's policy of not hiring homeowners, would they require the management company to rescind this policy? So I guess, let me just break this down. So the management company has a policy of not hiring homeowners. That's a good policy. Okay. Just from my perspective, it's probably best for the community to not be hiring homeowners, because if things don't go well, and the homeowner gets fired, it's going to be a bad situation. Trust me, I've seen this happen in other associations. If the board wants to rescind that policy, I guess the way to do it would be to ask the management company if they're willing to do that. I don't know if it's in the contract. The contract may need to be renegotiated, but that's going to have to be between you and the management company. But again, I'm on the management company side on this one. I don't think it's a good idea to hire homeowners who live in your community to work for your community. In some cases, I know it works, but sometimes it doesn't work. Okay, question number 17. From an owner. If the HOA board had a problem with the contracted management company's policy of not hiring homeowners, could they require... Oops, I'm sorry. I just did that one. Sorry about that. Okay, the next question. Number 18 from a board member. What is the definition of a dwelling? Would that include patios and roofs? Well, we want to look at what your CC&Rs in your claim is. Hopefully there's this definition section in the CC&Rs that defines what dwelling is. If we just look at like a law dictionary or a regular dictionary, dwelling is defined as any building, structure, or portion thereof, which is occupied as or designated or intended for occupancy as a residence by one or more families. And it can also include any vacant land, which is offered for sale or lease for the construction or location thereof of any such building, structure, or portion thereof. So like vacant land that's buildable. So would that include patios and roofs? I would say for sure roofs. I think it also would include patios, but we'd have to look at what your say is. Are patios, are they limited common elements? Are they common elements? Or are they actually part of the unit? If they're part of the unit, then it definitely be part of the dwelling. Okay, next question, number 19. From a board member, can an HOA annual monthly dues legally be raised by the board expressly to increase the community reserve fund? It just depends. I have to look at your documents. So, typically, if you are, it is a normal topic, or a normal thing to do. If a board wants to, increase their reserve contribution, they factor that into their budget, and the dues may be raised by the board to cover expenses and any, contributions that may need to be made to the reserve for the association. So can the board just do that without, a vote of membership? I don't know. I doubt it. You need to look at what your documents say. Typically, the board can raise the assessment rate a certain percentage without a vote of membership, but anything over a certain level needs a vote of membership. Okay, question number 20 from a board member. We had to shorten this one a little bit. Our association does not regulate street parking other than what the city would also enforce. If we hold a community vote in compliance with ARS 33-1818 and it passes, will we be able to enforce any type of street parking or only what the city street parking laws? Many residents are upset about street parking as our streets are narrow with vehicles on both sides of the street. It's harder for wider vehicles, including fire trucks, to get them through easily. Okay, so I would need to see your CC&R. So this law only applies to certain associations. So you'd have to be a planned community. The streets would have to be dedicated to the, the city, town, or county, or the public. Right now it sounds like, I don't know what your provisions say in your CC&Rs about on-street parking, but And the fact you gave me, you're only, enforcing whatever the city would also enforce. So I'm kind of guessing that maybe you don't have any parking restrictions. So maybe this new law that you're talking about, this 33-18-18, which, was created, 7 or 8 years ago. And now last year we had an update to the law that talks about affirmative action that planned communities need to take if they want to keep regulating their streets, if the streets are dedicated to the public. It's hard for me to comment on this without knowing more information. But if you currently aren't regulating on-street parking any more than what the city would be doing, I'm guessing your documents don't give you any more authority, right? And if that's the case, then you can't, do this unless you amend your CCNRs to have more regulatory authority. But this is a good question. You probably want to reach out to our firm to get clarification because this is an important topic and it's very timely because you're going to need to make a decision on this within the next year because a vote needs to be taken by June 30th, 2025 if you're one of those associations that falls into that category. Okay, next question, number 21 from a board member. According to ARS 33-1808, an association shall not prohibit the outdoor front yard or backyard display of the American flag or an official or replica of a flag of the uniformed services of the United States by an association member on that member's property if the flag or uniformed services flag is displayed in a manner consistent with the federal flag code. The federal flag code says no disrespect should be shown to the flag of the United States of America. The flag should never be displayed with the union down, except as a signal of dire distress in instances of extreme danger to life or property. During this political season, some homeowners are choosing to make a political statement by flying the American flag upside down. Applying the Arizona Revised Statute stipulation that the flag be flown consistent with the federal flag code and the exception regarding, the flag being upside down or union down as a signal of dire distress or extreme danger to life or property. Can an association require a homeowner to return the homeowner's flag to its proper upright position? And if the homeowner fails to comply, can the association sanction, including fine the owner for this behavior without them claiming it's free speech? This is a tough question. I mean, anytime we have a federal election cycle, we start to see more, topics like this. I mean, I think 4 years ago, and even maybe 2 years ago, we saw a number of flags that maybe had, disrespectful language pertaining to political candidates. Now we've got the United States flag being flown upside down. I mean, I guess I'm a patriot and I believe that the United States flag should be flown upright as a sign of respect, and that is consistent with the federal flag code. I had this question from a couple of different sources earlier this week as well. So this seems to be an issue that's, kind of coming to a head in Arizona. Here's what I recommend. If your association is in this situation, I think that you should send a letter to the owners reminding them of all these things that we just talked about, the state law, what the federal flag code says, and ask them politely to please show respect to our country and our flag by flying it upright. If they don't do it, then you're going to have to make a decision. Does our board want to start fining? Do we want this to be on CNN and, Fox News and the local TV stations, Arizona Republic newspaper? I'm guessing no. And so we're going to have to be really strategic as to whether we want to enforce this. What I have found, based upon my 27 years of experience, is that sometimes issues are hot topics only for, 8 months, 6 to 8 months. And this is one of those issues. I think once the election occurs, things hopefully will be more calmed down in our country and we won't be seeing questions like this. So it's up to your board. You're going to have to decide if you want to enforce it. I do feel that, you have the right to enforce it. It's just, this is going to be a hot topic. It could be pushed back and it could involve you in litigation. It could make you a celebrity on national news and local news. So as a board, you're going to have to talk about that. Reach out to our firm if you're navigating this situation and the owner refuses to put the American flag upright. We can give you some good suggestions on how to handle it. Okay, question number 22 from a board member. What is the status of the law that was passed last year that requires a vote of the membership to decide about on-street parking? My understanding is that the legislature was reviewing that requirement and was possibly going to not require that anymore. So we have the legislative update, which we're going to be sharing with you right now in our Zoom chat and then also on Facebook Live. So the legislature, as I said, is still open for this year and it hasn't closed yet. So we don't know. No bills have been passed that directly affect us this year. What I would say is I don't think anything's going to pass this year on this. There was a bill introduced, or maybe two bills introduced to discuss this, but I don't think it's something that is going to pass this year. But we have to wait and see because, like I said, the legislature is still open this year. Okay, next question, number 23. A recent monthly board meeting was posted as an open board meeting, but then additionally stated that open meeting would be Zoom only. Doesn't this Zoom only conflict with Arizona law, especially when the Zoom transmission does not originate in the state? Okay, so this is a great kind of post-pandemic question, right? During the pandemic, we were forced to move all of our meetings to Zoom, or most associations just did this. So there is a question because under the law, the meetings must be held in Arizona. And so, if you're having a Zoom meeting for your association and you have an owner who is demanding to participate in Arizona, what your association could do, and I know your association, I'm looking at the name, is you could have a Zoom camera set up in the association's office, which is in Arizona, and that person can walk to the office and watch the Zoom meeting there. And I think that would comply with Arizona law. Okay, question number 24 from a board member. Our property manager said that if we don't make a motion on an agenda item, that item is considered not approved. Is that correct? Well, if it is required to vote on something, like let's say to approve last month's meeting minutes or to hire a vendor, yes, you have to have a motion, a second, and then a vote to have it pass. So your property manager is correct in that way. But there's some agenda items on there, like the president's report, that you don't have to vote. So just keep that in mind. Next question from a former board member. Can homeowners and Arizona HOAs form a 501c3 nonprofit corporation independent of the HOA and immediately start raising funds through holding raffles for the sole purpose to improve the building? I have seen some other associations doing this. I have at least one or two other ones that have like a foundation that they've set up. So, check with your CPA and make sure that you've got the board's buy-in because this is something that, you guys need to be unified on. But I'm not opposed to this. I think it can be done. It's going to need to be, how you set up this corporation with your articles of incorporation will need to be very specific as to how the money can be used so that the money isn't misappropriated and used on something else. But I'm not opposed to this at all. Question 26 from an HOA. One of our board members said, we are only board members when we are in an open and executive meeting, 9 to 5. Our CCNRs and bylaws do not say that. Is there a state law? Well, I think there is no hard and fast state law on this, but here's one thing I'm going to tell you. When you serve on your board, you are a board member when you're at the board meeting and when you're not at the board meeting, right? And so you have to be really careful with your behavior, right? You can't be making crazy comments on Facebook, inappropriate statements. You can't be telling people things are approved, architectural requests are approved when it's just one person in the hallway or on the street. So, when you serve on your board, you're a volunteer, you're not paid, but your role extends beyond the board meeting. You have to act appropriately at all times when you're acting as a board member. Now, if you want to do something and you want to say, I'm acting only as a homeowner, you certainly can, but they're going to argue that, hey, this person's on the board and, you're going to be held to a higher standard for sure if something's challenged. Okay, next question. What is a reasonable amount of time to promise owners to review their architectural requests? Some requests are very simple, while others require review by licensed professionals, such as a request to move plumbing lines in a multi-story building. We want to treat all homeowner requests consistently, but we meet only once a month, and a month seems like a long time for simpler requests. So, it just depends. You're right. For simpler requests, we should be able to just get the, approval out to them quickly. For requests that are more detailed, you may need more time. I don't know for your association if you have a specific time that you have to respond by. If any of you have that, you have to comply with that in your CC&R. So if they say you have to respond within 45 days, even if you don't know, like you're investigating it, you should just deny it and tell them we're investigating it. But we need to deny it to meet the 45-day or 30-day requirement to respond. So I think, what is a reasonable time to promise owners? I think just try to be responsive, right, to your owners. If it's something that's easy and your board can do a quick meeting to review it, or your architectural committee can do a quick meeting to review it, and so that they can get started on their project, great. If it's not something that can be done quickly, then just communicate. That's the most important thing. Communicate to your owners. Okay, here's what we're doing, and we'll get back to you within estimated time, give them that time period. Okay, question 28 from a Tucson board. The Pima County Assessor's Office assigns a code to each property: primary residence, income producing property. They get a code for one if it's your primary residence, different code for income producing property. We have 3 units that are not rentals, but have the code for income producing property. I've told the homeowners that their property has an incorrect tax code, but nothing has been done to correct it. What do you legally go by, the code that is recorded or the fact that the property is not a rental? Rental tenants are not able to speak at meetings because they are not owners, nor are they allowed to vote, but they are really homeowners. Okay, a couple thoughts here. I don't think that we should be getting involved in this, right? That's this homeowner's personal business. The only time we get involved in it is if the owner is renting the property and, they haven't told the county yet, or the city that they live in, that it's a rental property. Then the board can contact the city or the county and ask the county to look into whether this is a rental or not, because the association thinks it is a rental and it's not listed as a rental. I haven't really ever had the question where it's listed as a rental property or a rental income producing property, but, it's not, or the board thinks it's not. And so I guess my thoughts on this would be, you certainly can clarify it with the homeowner, but if they don't really want to get into it with you, they may not have to. Whoever's the record owner, they can come to the board meeting. So, we want to be careful that we're not telling them just because they have this code with the assessor's office that they can't come to the meeting or that they can't talk at the meeting. That if they're listed on the deed, they certainly have the right to, as a homeowner, to come to any board meeting at an appropriate time during the board meeting. Okay, question number 29 from a board. We have a new board member who has put our board in turmoil. 2 board members resigned the first month. I am tired of exchanging emails with this person and would like to sit down and try to come to a mutual understanding, but I feel I need a witness present. If I have another board member here, that will make 3 board members. Do you have any suggestions? We actually just did a memo on this week on this exact topic of, boards in turmoil and how to handle things of this nature. You're right. If you bring a witness, it's 3, you've got a quorum. If it's a 5-person board, that's a quorum. What you could do is have a non-board member, like a committee member, be your witness. That's one option. Or really the best thing to do, this situation sounds like a really bad situation. You should really think about having us come in and do a boot camp, because we have been very successful in helping boards navigate problems where you have a difficult board member or a change up in the board where things are, the dynamics of the boards have changed and there's a lot of problems. So those would be 2 suggestions to help your association. Okay, I have another insurance question. Lots of insurance questions today. Just so you know, we have a cheat sheet on insurance on our webpage at mulcahylawfirm.com. So that might be a resource that you may want to look at too in some of these insurance questions. Okay, so question 30 is from a prior board member and a homeowner. There are more than several homeowners who would like to cancel the blanket insurance and have each condo owner carry their own insurance for inside and out. How do we legally get this started, and what would be our first step? I think, wow, a lot of questions on insurance being canceled and wanting to switch insurance responsibilities from the association to the owner. I think the first step is for your board to reach out to our firm. We can take a look at what your documents currently state. We can take a look at the Condominium Act and find a solution that hopefully will work for your association. Next question, 31, from an owner. Several owners have expressed a desire to recall our HOA president. Owners would like to post a notice of assembly of owners on our community bulletin board. In the past, when owners post signs on the community bulletin board, HOA board members remove the signs. Do owners have a legal right to post signs regarding an assembly of owners? Can owners post signs on the bulletin board or on their property in support of or recalling the association's president? Okay, so a couple questions there. So there was a law passed several years ago that says that owners have a right to assemble, and that if you want a notice posted, you have to give it to the board, and the board has to post it. So just so you know, you can't post it necessarily on the community's common areas, but the board is required to. And yes, you can look at the sign statute, but the sign statute in Arizona does allow owners to put property signs on their property in support of or against any sort of community measure. There are some restrictions on that, like it can't be put up until after the ballots are sent out, and then I think it has to be down within X number of days, like 3 days. I have to look at the statute specifically. Before it has to be taken down 3 days after or something like that. So just know that that's a restriction. You need to look up specifically what the requirements are. Okay, question number 32 from a board member. Is there a statute of limitations on an HOA's board's time to confirm homeowner compliance to the specifications and conditions of a processed architectural change request? So is there a statute of limitations on a time for the board to confirm compliance to an approved architectural change request? I think that's what you're saying. So how long do we have to check to make sure that they built, something in compliance with whatever the HOA's approval is? So, I would just do it as quickly as possible, like within 30 days. There is no hard and fast law, no statute of limitations per se, to address this issue. Statute of limitations actually is probably maybe not the right way to characterize it, because that's, a time period under the law that you can sue an owner. But I would just say, generally speaking, check it within 30 days of the project being completed. And when you give the approval, say when you're finished, please contact the architectural committee or the board, within, when your project's finished, and, give us an opportunity to come out and check. Okay, next question, 33. If someone is married, but the spouse is not on the deed as an owner, can the spouse attend board meetings without written permission from their spouse who is on the deed? So short answer, no, they cannot. If they're not on the deed and the board doesn't allow non-owners. Now, of course, the workaround on this is that they get a note from their spouse saying that they are the designated owner on this property or designated representative on this property, and then they would be allowed to attend the meeting and talk. Okay, question number 34 from a board member. Please discuss how a condominium HOA can be held liable for not having security cameras or some type of security in place to protect its residents. Also, do you have a cheat sheet on this? So, yes, short answer. We have a cheat sheet called Preventing Crime and Limiting Liability, which we're going to be sharing with you. If we haven't already, we also have a blog on security cameras, which I think would be helpful here. So, it just depends. I don't know enough about the facts here. If your association has a history of, crime or vandalism or, bad behavior on the common areas, the association should be doing something to limit its liability and, keep its members safe and free from harm. Because there's a case out there, from many years ago that talks about this exact specific situation in Arizona. So can we be liable for not having security cameras? I don't know. Maybe. It just depends on what the facts are regarding what the danger is in the community. And look at our cheat sheet. We give you some great suggestions. Reach out to our firm if you're worried about this, because I could be, a sounding board to listen as to what type of issues you have in terms of security issues and what would be some good recommendations based upon your budget to handle, notifying the resident that this is going on and maybe have an increased security patrol or possibly have cameras. We can kind of look at it from all angles and determine what's the best, situation to help your association. Okay, next question, number 35. If the reserve study does not provide for a specific expenditure to be funded, such as the replacement of the sewer line or major landscaping project, may the board legally spend reserve funds on such expenditures? So, it just depends. Sometimes reserve companies forget to include things in their reserve study, and maybe they didn't look carefully enough at the CC&Rs, or maybe there was a misunderstanding on something. So, it depends. If this is something that is a common area and it's a long-term capital improvement, it's very likely that you will be able to spend reserve funds to fix it. We have a great cheat sheet on reserve funds for community associations, which I encourage you to take a look at. You can find it on our website, or we've also shared it with you here on Facebook Live and Zoom. Okay, question number 36 from a board member. We currently have a property that is seriously behind on HOA dues. The record owners are deceased and ownership has not been transferred to the surviving family member. The property has been put in abatement status, not habitable for living by the city of Glendale, and he does not live there anymore. Who do we file a lien against, or can we even file a lien since the legal owners are all deceased? This is one that I'm going to suggest that you contact our office. We need to figure out is this property, does it have a mortgage or deed of trust on it? This might be one where we need to have a foreclosure and a sheriff's sale. And that may be the only way to get this to a new owner. You may want to check with the city on their abatement status and what else they might be doing to try to get this in compliance. But if the families wash their hands of it, it's unlikely that is going to be a viable option. So reach out to our firm. I think probably the best way to handle this would be to look at how much is owed, look at if there's a mortgage or deed of trust on the property, and likely foreclose, have the association, become the owner or sell it at a sheriff's sale to a third party who's going to come in and fix it up and start paying dues. Okay, next question, number 37 from a board. Is it legal to pay HOA fees with cash, or are boards legally required to accept cash from owners on assessments? We just changed to a hybrid HOA management system and have an online system that can only use check or accept check or credit cards. So, cash is kind of a thing of the past, and there's a lot of, there could be some fraud if somebody's paying cash. I think there's not a lot of accountability in terms of the money went into the account, et cetera. So I think that I would recommend that you not accept cash and that you go forward with the online system that your new management company is proposing. Question 38 from a board member. Does all board voting have to be done in a meeting setting, or can it be done by email or text? We had a special board meeting to let members know we were choosing a vendor out of the 5 bids. The vendor the board chose fell through. So a decision like this would definitely need to be done in an open meeting where you give 48 hours notice to the membership. There are some decisions emergency decisions that you can't wait 48 hours, that you may be able to make the decision by email, but it would have to be a true emergency, situation, and you'd have to follow the law. You have to take minutes, and then at the next regular board meeting, you'd have to read into the minutes what the emergency was and what action you took. Okay, question number 39. There seems to be a misunderstanding from new board members and residents on the differences in using funds from the operating expenses, and reserve fund. Would you provide some simple explanations of how a reserve fund is to be used legally and the items we can use it for? So again, I would suggest that you look at my cheat sheet on reserve funding. I think that's an excellent resource on this. Just generally speaking, I can only give you just a little bit of time here. You're welcome to call my office and I can elaborate more. If it's listed in the reserve fund and the reserve study as a reserve item, you can use reserve funds for it. If it's, an operational expense that is listed on your budget as an operational expense, like attorney's fees, the power company fees, water fees, management company fees, those are not going to be, you can't pay, those fees using the reserve fund. So that would be kind of a good rule of thumb. Take a look at our cheat sheet. Question 40. From a board member, we shortened this one up a little bit. Our association documents were unfortunately an outdated boilerplate set of documents. Consequently, there are a number of provisions that are not in compliance with various state and federal laws. We've been unable to get past the apathy of homeowners to make amendments because 10% of the interested homeowners fall far short of the required minimum 67% yes. House Bill 2698 sounds interesting, but doesn't make any meaningful changes. Are there any laws that allow an association board to amend the governing documents without the full 2/3 vote of all the homeowners? So quick answer on that would be no. House Bill 2698 would allow you to remove any provisions that are like in violation of the Fair Housing Act or that are discriminatory. But it's not, like a broad sweeping law that, is going to allow you just to amend anything to make it comply with Arizona law. Okay, question number 41 from a board. We have an architectural committee that is often unanimous in their decisions, and on occasion, a homeowner will take exception and request an appeal to the board. While we recognize it's the board's responsibility to enforce the CC&Rs and other governing documents, the board sometimes acts as a mediator, granting what amounts to an exception of the rules, but make a reasonable interpretation based on context and history. The Architectural Committee considers this application of an exception or a reasonable exception to be diminishing their authority and a failure by the board to uphold the strict standards of the CC&Rs. Our CC&Rs, however, state in a section called Violation of CC&Rs, an owner may appeal a decision to the Architectural Committee to the board. The board shall determine the appeal by a majority vote of the directors, and the board decision shall be final. Question: does the board ultimately have the power to interpret the CC&Rs or even disregard them by approving an appeal that effectively grants an exception to the CC&Rs? Or does the board have to follow the strict interpretation as determined by the Architectural Committee? Okay, so this is a great question. I mean, on some of these difficult ones where there's an appeal and the board, is potentially going to be going against what the Architectural Committee says or what the documents say, you really should be reaching out to your legal counsel to get advice. I mean, there are certain exceptions. Like, let's say somebody wants to do something and 67% of the owners already have this, but the documents say you can't do it. I mean, likely I'm going to tell the board, you can go ahead and approve that because there's been a disregard of that provision in the CC&Rs. But, there may be other situations where, an owner's had it for 6 years, the change to their property. And, legally, we're not going to be able to enforce it. So we may make an exception on that. But, I mean, there's this push and pull between the Architectural Committee and the board often in associations, and they don't always get along. And that's really sad to me because you guys are both on the same team, right? And there may be times where the Architectural Committee gets overruled and you just have to accept that. And the board needs to be making good decisions, though, if you are going to overturn the Architectural Committee, and make sure you're on sound legal ground by checking in with your legal counsel so that you don't have any legal issues by any decisions that you're making that might negatively impact the association. Okay, question number 42 from a condominium. I was elected to our board in January of 2024. As a result of my election, 2 board members resigned effective immediately. Both members were voted in by the members at our January annual meeting. Our bylaws state that board members shall have the right to substitute or appoint new members of the board. Condominium Act says the board may fill vacancies for unexpired terms. Nonprofit Corporation Act appears to indicate that because the 2 board members that resigned were voted into their positions by our members, 2 vacancies should be filled by a vote of our members. Which one of these rules takes precedence? I would go by what your bylaw states. So, your board can appoint the 2 new members of the board pursuant to what your bylaws state. You don't have to take this back to the membership. Okay, question 44 from a prospective board member and an interested homeowner. If significant deferred maintenance exists in my community, for example, like the pool, spa, walls, can an association force a special assessment by court order or other action of law if a membership vote fails to authorize one? So unfortunately, no. The only exception to that would be is if like a receiver is appointed to manage the affairs of the association. That's the only time I could see that coming into play where you could force the membership, to pay a special assessment. Otherwise, you'd have to get a vote of the membership. Okay, question number 45. I'm just going to do a question check here. It looks like we have 64 questions, so we're getting close to the end. Question 45. As our community becomes more diverse, what is the legal obligation to provide association documents in other languages? I've had this question before. I don't think you have to provide it in another language, meaning English is the main language. I've never had a case where we've been forced to do that, and this issue has come up before. I think there are lots of translation systems that they can use to translate it, and that is not something that we're required to do. Question 46 from an owner. Lots of discussion going on about whether the HOA can enter the backyard to inspect something, especially without notice. In our case, it is written in the CC&Rs that they can. Is this legal? So yes, it is. Usually there's a notice requirement that needs to be followed. So you just want to make sure that you follow whatever the notice requirement is before you enter anybody's property to inspect something as a board member. Okay, question 47 from a board. Our board is stymied by the open meeting law, where we talk only at board meetings. Respectfully request an idea for the board to talk about upcoming agenda items before the scheduled board meeting. Well, kind of the workaround on the open meeting law, the loophole per se, would be that less than a quorum of the board discussing. So the one board member can reach out to another one as long as that's less than a quorum. But it is the law and we're required to follow it. Question 48 from a board. If a mechanical lien is placed on our HOA, will the lien prevent or hinder all 133 owners from being sold or deter future sales? Likely not, because a mechanical lien is like typically when you're doing like a large project, the vendor will put a pre-lien on your property, which just says that, hey, this work's being done and the association's agreed to pay for it. It's not an actual lien. And so it should not prohibit the owners from selling the property. The only time that it would prohibit it potentially, and it wouldn't prohibit it per se, you just have to pay, your share, which this never happened. So it's kind of, I hate to even bring it up, but I have had situations where an association has a judgment entered against them and condo, and the owner has to pay their share of the judgment, at the time of any sale. But that's happened one time in 28 years. So I don't see that as a problem. The mechanical lien's a pre-lien. I wouldn't worry about it. Question 49. Our community has just lost our FHA condo project approved status due to underfunding. What's the journey to resolve this? This has been a long time coming, which is why I joined the board, trying to get my association to hire your firm. Well, thank you. Okay, a couple of things. You need to look at what are the current FHA condo requirements to be, have the funding, and basically what this is it's you're certified by FHA and you can get these government loans. Anybody who's buying or refinancing can get a government loan to pay for that unit or lot. So, look at what the current standards are, look at what your association is deficient in, and then come up with a plan to get the numbers better. The bottom line is you have to start budgeting and saving for your reserve because the reserve number looks bad, and that's why they don't want to give you the loan. They don't want to give you the certification to get the loans in your community. Question 50 from a board member. In accordance with the new law regarding street parking regulation, our HOA initiated a vote of the members. We received votes well over the required quorum with 96% voting yes to continue regulating no parking of trailers, boats, etc. on the streets. We have public streets, so we do not regulate day-to-day car parking. We are hesitating to have the votes recorded because although we sent a detailed letter explaining the law and what our current CC&R state about parking, we did not hold a separate membership meeting or forum strictly for this purpose. In the letter, we did invite any open discussion if needed, but no one requested that. We did discuss it at an open board meeting, but only 2 homeowners were there. Since we did not have an open meeting in person about this, is there a risk if we go ahead and record the votes in the future, someone decides to fight this in court? Is it a problem? It's been in our CC&Rs for 30 years with no problems. There is a risk that, you could have an issue on this because you were required to have a meeting and owners were required to go, either by absentee ballot or in person. You know your community best. Is it a risk that you think someone's going to sue you for? You'll 6-year statute of limitations that they can sue you. You just have to weigh, the risk with whether or not you think this is going to be challenged in the future. Okay, next question, number 51. If current CC&Rs prohibit hard flooring in second floor condos, would the HOA need to comply with House Bill 2141? CC&Rs have not been amended. Okay, so your CC&Rs have some noise reduction, information in there. And let's see, with the HOA need to comply with House Bill 2141. So this is a new law that is going to go into effect 90 days after our legislature closes for the year this year. Let's see. So we talk about what House Bill 2141 is, Rise 33-1221. And it mainly deals with the owners type things. I'm not really sure that CC&Rs are going to be enforceable, in my opinion. But basically what this law says is, let's see, a unit owner may make any improvements or alterations to the unit owner's unit that do not impair the structural integrity or mechanical system. So that's not going to apply. In addition to the allowed modifications as prescribed, in this section, the association shall not prohibit an owner from improving or altering the interior of their unit in a manner that may disturb adjacent unit owners or occupants if the unit owner purchases and installs at the unit at the owner's own expense reasonably necessary improved materials. So it is possible that an owner could have an argument that if they want to put in hard flooring, they could, but there would have to be significant sound reduction measures as part of that hard flooring. Okay, question number 52. Looks like we have a total of 64, so we're cooking now. Only a few more left from a board member. The board approves a new property management company. Property management company makes multiple changes in the agreement after the board's approval. President sent an email to the board if she can approve the contract. Treasurer makes comments on the new updated agreement and emails it to all board members. No response from the board. President signed the contract, not letting the other board members know. Is the property management contract valid? Lots of issues here. So, bottom line, just because this is a very short question and answer thing is, yes, it probably is valid because the president signed with apparent authority and the property management company is going to think, this president had the authority of the board and it's very likely a valid contract. Now, internally on your board, this is not good, right? Because maybe there was a miscommunication. I'm going to think the best in the situation, but there's a disconnect here. You don't have any legal arguments, I guess, against the president other than, hey, I wish you had taken my thoughts into consideration and I wish this had been a board vote. It's just not a good situation. So what I would recommend, talk about it as a board, make sure this doesn't happen in the future. And when the contract's up, renegotiate the contract with the terms that everybody agrees on in an open board meeting. Okay, question 53 is from a long-term board member who's back on our board, a different board. Our association has a provision in the CC&Rs that restricts owners from parking overnight on their personal driveway. There is not really any accommodation made for an alternative should an owner have a need other than for guests and for a very limited number of guest spots at the pool. I've asked the reason behind this regulation and not gotten a clear answer. We have owners who are opting to pay large violation fines because there is no other alternative for them. And the fairly new owner and board member this year, I want to address this appropriately since it is already a major point of contention. Is there a restriction of owners' private property reasonable and legal? And if so, is a CC&R change the only or best way to handle it? So we do see this type of a restriction in the CC&Rs from time to time. It's pretty common that no parking on the streets. But where it really comes into play is where, the streets are large enough to accommodate on-street parking. And there's only a handful of visitor parking in your community. And the owner has, 4 vehicles and a 3-car garage or something like that. So you just have to think about as a community, is this working for us anymore? And it sounds like there's some issues with it. So I think maybe you should do a census, see how many people are actually parking in their driveways. Is this something that we want to change going forward? Or is this something that we feel strongly that we want to keep this because we don't want a bunch of, cars parked in people's driveways all the time? My only worry about this is times are kind of changing and, people have more than one car. And if the owner has their garage cleared out and vehicles parked in there, it's not like a storage, hoarder's paradise. And they have an extra car that's parked in the driveway. I'd like to see the CC&Rs. I think, it is enforceable, but if this goes to a jury, I mean, I don't know. Sometimes people are going to think this restriction might be, too unreasonable. And then, who knows, maybe court won't enforce it. They should because it's in the contract. But so I think as a community, what I would suggest going forward is find out how homeowners feel about this. If they want to get rid of the provision, then we'll need to do an amendment to the CC&Rs. If they don't want to do an amendment, then we've got to figure out how we're going to handle owners that are doing this. Are they going to get rid of their vehicle? Are they going to clean up their garages so they can park in there? Do we have enough overflow parking and guest parking to accommodate them? All of this needs to be considered by your board. Okay, question 54 from a board. Can the board force an owner in the HOA to paint their house a CC&R compliant exterior paint color if their house color was approved in error by a previous ARC? Our HOA board has suggested to an owner who has a house in the early stages of construction that he pick a CC&R compliant exterior paint color to paint his house, since his color was approved in error by a previous ARC member. Also, the HOA board has sent out a notice to all members of the HOA they want to repaint their house the same or different non-compliant paint color. HOA ARC will not approve it if it is not per the CC&Rs. The owner says he refuses to pick another color, and in the future, when he goes to repaint it, he's going to use the same color. Okay, this is a difficult situation. I mean, if he has a valid architectural approval of the paint color, we have to allow him to paint it this time. When this owner goes to paint it again in the future, I think we need to make it very clear that, hey, this was an error that you're getting this paint color. When you go to paint it in the future, you will have to use the approved paint color. You'll have to use the color for the association at that time. Okay, question 55. Our HOA has a long-term board member that is minimally involved at best. Since the advent of Zoom meetings, the board member calls in, no video feed, typically muted, and usually needs prompting to engage in general meeting business. I'm laughing because I have this at my association too. During the executive session, this person is 99% silent. At the last meeting, the board member engaged in a vote and stated, "I have to get back to work." The muted phone stayed on throughout the rest of the meeting, but no further engagement, including our typical extended goodbyes following the meeting. Name recognition ensures continual votes on the board. How best do you suggest getting this outlier board member to lead, follow, or get out of the way? I think what I would do is have the president call this person and find out if they really do have the time to serve on the board and just kind of give some of the examples that you've given in this question. I mean, the bottom line is hopefully that they'll be honest and maybe they'll resign and you can appoint somebody else. If not, just know when elections come around next time that you want to find somebody who's going to be more engaged. Okay, question number 56 from a board member. We have a personnel committee of 3 board members out of 7. I am a new board member. They're allowing executive sessions of just 3 board members. There's no mention in our bylaws or other founding documents allowing the inclusion of board members to attend these closed meetings. Please advise. So I don't like the idea of personnel committee, although I know the association that you're in is a very large community. So I'd have to see, is this something that's in your documents? You're saying it's not. It's unusual. So I don't know. It's a committee, so it's maybe not necessarily a board meeting. This is kind of a tough question. So if it's a separate committee that's not a quorum of the board, and it sounds like it's not because it's 3 out of 7, it probably is okay. If they don't meet regularly, they don't have to get 48 hours notice. What you might want to do is just say, hey, I'm a board member. I'm invested. I want to attend. And if they say no, ask them why. They're probably going to say there's sensitive information. You can say, hey, I'm on the board and, I'm entitled to hear everything, even what's discussed in executive sessions. So hopefully they'll do the right thing and let you listen in. Okay, number 57. A current condo owner planted a tree on what would be common property in front of his condominium unit. If he won't remove it and the board has it removed, can we put a lien on his unit for the cost? So short answer would be no, I would not suggest doing that. These are tricky situations when you have an owner that puts a tree on common areas. You may want to reach out to our firm to discuss it more, but typically the board will either remove the tree and, it depends. actually, typically the board will let the tree stay, but they say to the owner, that don't do this again. And maybe the owner, has to maintain it, like trimming it or something. This is a tricky situation. You may want to reach out to our firm so that make sure that you handle it right. Okay, question 58. Please discuss the requirements for our HOA in regard to parking restrictions on the streets within our gated community. The community was established in 2000 and is in the CC&Rs to not allow CC&Rs. Do we need to do that community vote under the new law? So if you're a gated community, it's likely that the streets are not dedicated to the public. So that law is likely not going to apply to you that we've talked about earlier today. Question 59. A resident. As residents, we cannot get maintenance to clean the sidewalks, common areas, clean or close the dumpsters. They have never been cleaned in 9 years. We are overrun with flying rodents carrying the trash around the complex. Nor can we get management to fix the irrigation, which is spraying into cars and the parking areas. This complex has a self-appointed declarant. There is no board and no board members. Is there a community organization that we can contact? This does sound like an unusual situation. There really isn't a community organization. I mean, I guess you could reach out to your neighborhood services department for the city that you live in to make a complaint about the association. As owners, I think you may want to band together and maybe hire a lawyer to send a letter to the self-appointed declarant. That would be one recommendation I have, just kind of at first glance. Okay, question 60. Our community manager waived some large fines without board approval. Our policy is no fees are to be waived without board approval. Do we have any recourse? I guess I would find out from the manager, like, why did you do this? It is inappropriate. You may be stuck with it if they put it in writing and sent it to the owner. And I think it's something that you may want to escalate to the management company president because this is not customary. The board is the one that waives fines. Now, I don't know, maybe the manager thought the board was being, not being rational or whatever and on a fine or something. I don't know, but you need to open the lines of communication. It's not appropriate what they did. But I'd like to hear more why they did it. And you may be stuck with what they did if they put it in writing. Okay, last 3 questions from a board. Regarding the new Phoenix and Arizona regulations regarding ADUs and casitas, back to this question. Can we, a 60-home gated community with private streets, elect to remain under the old Phoenix regulations, which mean that we can't build on more than 45% of the lot and no kitchen or stove is allowed in the alternate dwelling unit? Okay, so the first place to look for information regarding alternate dwelling units is your local ordinances, because these may restrict or prohibit the construction of ADUs on lots. Also, there are setback requirements that attached ADUs must maintain a gap of at least 5 feet from the property's side and rear lines and 5 feet from any pre-existing structures on the lot. Lastly, the current laws do not preclude associations from regulating or prohibiting ADUs. So if your association has specific setback requirements, this law does not say that those are, they can be disregarded. They have to follow the same procedures under your documents to get architectural approval. And you don't have to enforce this new law that, is being placed by Phoenix. You enforce what your CC&Rs state. Okay, question 62. Does the new casita law for municipalities trump HOA restrictions? So great, just answer that. No, it doesn't. You still have to comply with your CC&Rs and get board approval or architectural approval. Last but not least, final question for today. Can you provide your thoughts about community security cameras like flock safety? Do these cameras create more liability for the HOA? So we've had 1 or 2 associations that have come to us with proposals to install the flock security cameras. We reviewed the contract. We didn't see any issues with it for that particular community. And from what I've heard, it's been a good thing for the community. If you aren't familiar with it and you're listening in today, one thing that you may want to consider is Google flock cameras, and you can hear about what they do. They cameras that are installed in your community. They're tied in with local law enforcement, and it appears to be a really good thing from my perspective. So it's something that associations should consider doing. Okay, that's it. We got through 63 questions today in an hour and 33 minutes. Thank you so much for being here. In June, we have our other neighborhood services event, which is going to be the third Tuesday of June. And you can go to our website at Mulcahy Law Firm to look at what class topic is going to be for that particular class. If I remember correctly, I believe we're talking about a variety of topics that day, mainly dealing with like problems that come up in associations. But go to our website to get the exact class that we're going to be teaching. Another friendly reminder that we are not going to have our first Friday the first week in July. So you're going to get the month off in July from First Friday questions due to the Independence holiday on July 4th, which is the day before the first Friday in July. So we won't be having our first Friday event for the month of July. So we hope to see you later this month on the third Tuesday of the month for our neighborhood services class. Go to our website for the topic at mulcahylawfirm.com, and we'll look forward to seeing you again in August for our next First Fridays. Take care, everybody. Have a wonderful 4th of July, and I hope to see you for our neighborhood services class in a few weeks. Take care.
Don't forget, our free cheat sheets are available for download at mulcahylawfirm.com. Please go to iTunes or your favorite podcasting platform and leave us a rating and a review.